This is a big topic, and it's brave to try and cover this adequately in 30 minutes. You have in the files in front of you a series of long notes as well as the slides from this talk. So have a look at the long notes when you have some time on your hands. The reason why I thought it was an appropriate topic to address at this stage is, from my own personal experience, I've seen quite a significant increase in these sorts of cases coming across my desk in the last few months. Some of them are historic, they refer to things that have happened some time ago, but quite a number of them are actually involve transactions that have arisen during the pandemic. And I think there is a number of reasons why that is so. According to a recent survey by Aviva, 50% of people who bought during the pandemic regret now how much they paid. 23% paid more than the asking price. 94% said they felt pressured into buying and didn't pay enough attention to the property. And here's the killer, 92% said they'd afterwards found problems with the property that they weren't aware of at the time when they were buying. Now, a fair number of those are going to fall into the dripping tap variety, I expect, but quite a number are going to involve something more serious. And so what we have is quite a few salty buyers who didn't buy what they think they were buying and are now going to look to blame someone. And the three people they can look for to blame is the seller, is their own solicitor for not having spotted the problem, or the surveyor for also not having spotted the problem. This talk involves cases against a seller, and there are a number of steps, some of which you might not expect to take, but you should take as if you're acting for such a buyer who's thinking of bringing such a claim at the outset. The first two are the obvious ones. Can you find the seller? Are they still good for the money? Or have they disappeared off the face of the earth having sold? The third one is an unusual one to address right at the start, is this. Is there really any loss? Because most of these claims are going to, as we'll see, most of these claims are tortious claims, and so the primary measure of damage is going to be the difference between the price paid and the value of the land at the time. So if, despite the problem, the buyer only paid what the land was actually worth, he has no claim. He may have a consequential loss claim. And it's worth checking that at the start before you even get into the issue of liability. And the reason for that is the fourth thing that you should check at the start is what the seller said false. Now that might be obvious in some occasions, but it isn't in others. And in particular, quite a number of these claims involve either rights which the buyer thinks he has over the neighbour's property, or rights which the neighbour starts to exercise over the buyer's property, and that's the point of dispute. Now, if they're documented, it won't be too difficult to determine whether or not what the seller said was false. But if they depend, if it's a prescriptive claim, for example, then in order to sue your seller, you have to prove that either the rights you thought you have you didn't have, or the rights that you weren't aware of that your neighbour has really existed. In other words, it's not enough to settle with your neighbour, or it's not enough to say a claim has been brought. You have to prove that what the seller said was wrong. Sorry about that. You have to prove that what the seller said was wrong, and that means actually proving that the neighbour was right in either asserting the rights over your land or disputing the rights that you think you have over his lands. And that is quite a significant burden. But assuming your buyer is not deterred by that, there are three potential claims that he has against his seller: misdescription, misrepresentation, and non-disclosure. We'll deal with the first and the first misdescription. Almost certainly this will not arise. In 30 years of practice, almost 30 years of practice, I have never come across a claim of misdescription. The reason is this, is that a misdescription requires there to be a difference between the land as it is and its, and this is the important bit, the contractual description of it in the contract of sale. So if it was a sale of unregistered land, and it was all those 6.75 acres of land known as Follyfoot Farm, and you can show that it's not 6.75 acres, it's 4.37 or whatever it is, that might be true. You might have a claim. The problem, of course, is that I think about 94% of land is now registered, and so almost every transaction you'll come across is a sale by reference to the registered title. And the problem for a misdescription claim is that you will be the description of the land will be the land by reference to its registered title. That's what the buyer is getting. So there is no contractual misdescription. The problem is, what does that registered title actually mean? In other words, what rights does it carry? What rights is it subject to? And that's not a misdescription claim. That, if anything else, is going to be a non-disclosure or a misrepresentation claim. So that's why these claims are vanishingly rare. I don't expect ever to see one. Remedies, I suggest you look at the long notes if you're interested in this, as I say, because it is such a rare and unusual claim to bring. Almost all your claims is going to be a claim in misrepresentation. And the first thing to point out is that you require something positive here. A misrepresentation means that something must be represented. In other words, put the other way, the rule of caveat emptor is still the default position. Let the buyer beware, the seller has no general duty to disclose. And there's a stark example of this that was in the Times a couple of weeks ago, where a buyer in the US sued the seller for not having disclosed the fact that the house in question 20 years ago, more than 20 years ago, events had occurred which were later made into the horror film The Omen. The buyer lost, not surprisingly, because the seller hadn't said anything about that. They'd kept stum about it. I bet in America they even probably tried to sue for failing to give vacant possession on the basis there were ghouls and spooks still in the house that hadn't been cleared by the seller. That didn't win either, by the looks of it. But the general point is, caveat emptor, you've got to prove there's a positive statement. So when you look at the textbooks, there look to be 4, even potentially 5 types of claims here. It's far too complicated. There are really only 3. They are innocent misrepresentation, negligent misrepresentation, and fraudulent misrepresentation. Now you'll see Section 2.1 of the Misrepresentation Act gives a 4th potential claim. However, for reasons we'll come on to, that is effectively a negligence claim in all but form. And so you're still there to prove innocence, negligence, or fraud. The difference between them is, the main difference is that if it's only an innocent misrepresentation, you're limited to a remedy of rescission and nothing more than that. For the other 2, you can have a damages claim as well. There's a 5th element that I should say, in that Section 2.2 of the Act gives the court a discretion to give you damages in lieu of rescission. But that's only affects the remedy and not the right itself. So we're looking really at the 3 main ones: innocent, Section 2.1/negligence, and fraudulent misrep. And there are 7 common elements to all of those claims. What the buyer must do is show there was a statement made by the seller or his agent to the buyer or his agent, which was false, on which the buyer was entitled to rely and did rely to his detriment. You'll see these are all in the notes, so don't worry about writing them down. Those are 7 elements that any buyer bringing a claim must prove. There are, however, additional elements that he would have to prove for negligent and fraudulent misrepresentation that mostly deal with the knowledge or intentions on the part of the seller, and we'll come on to those in due course. Let's have a look at the sort of types of statements that are involved. A statement for these purposes can be express or implied. For the most, and when it's express, it can be oral or written, of course. The vast majority of these sorts of claims are written representations arising out of the seller's answers to the seller's property information form or the commercial property standard inquiries, the CPSE or the SPIF. Implied representations can sometimes be through conduct, but there are also implied representations, as we'll come on to in the SPIF itself, the answers to those inquiries. The classic example of an implied representation by conduct is the seller who paints over dry rot, and he's thereby misrepresenting the condition of the property. The difficulty a buyer has in those sorts of cases, I had one of these a couple of years ago, is to differentiate between the seller who's trying to cover up something and the seller who's simply trying to fix the problem but doing a really bad job of it. And that can sometimes be a hard dividing line division to draw. The main, however, area of implied representation, as I say, is in relation to the answers to the seller's property information form. And there are some of them where the question is framed, is the seller aware? Now, the seller may think that as long as he doesn't know about something, doesn't bother to make inquiries, he's Nelsonian blind, doesn't want to look, he says, well, I'm not aware of that. Well, unfortunately, he's not entirely immune from liability if he fails to investigate, because he is impliedly representing by saying, I am not aware, that I have taken reasonable steps to find out if that is the case. And that's the William Sindel case. And he does more than that. He impliedly represents that his records are in such a state as to enable him to answer that question. But the SPIF and the CPSE aren't lawyers' forms and are not, and so the answers aren't meant to be those of a lawyer. It's meant to be something that the buyer can, the seller can answer without any specialist knowledge. And certainly, if you look at the different versions of the form, the more they go on, the more they become matters of fact rather than matters of opinion. Nevertheless, there are questions of judgment which a seller still has to exercise when he's answering those forms, and it's certainly possible to get it wrong accidentally. I'll give you one example, and we'll come on to this in the participation section. One of the questions is 3.1 in the standard form, and what it asks is this: have any notices or correspondence been received or sent which affect the property or a property nearby? Affect? Nearby? Neither of those is defined. And it's not a matter of opinion, it's a matter of judgment then, unfortunately, as to what affect means and what property is near enough in order to qualify as nearby. So if you're acting for a seller in those circumstances, in order to make sure that you don't get sued by him for his false statements, you should recommend that he is as candid as he reasonably can be when answering those. You also have to prove that those are statements. The second major element that you're going to have to prove is falsity. And it's often assumed that once you prove that a statement's been made and what it means, that falsity will be apparent, will be clear. As I say, unfortunately, that's not always the case. It will be in a significant number of times, but not always so. The two major elements where this, two major occasions when this proves a significant hurdle to overcome is the one I mentioned earlier, which is the neighbour who either disputes your rights or asserts that he has rights that you weren't told about. Now, as I say, if they're documented, falsity will be easy to establish. If they're based on prescription, then that might be an extremely difficult hurdle to overcome. The second element of falsity where it can be difficult to prove is where the seller is simply repeating what he himself has been told, and what he's been told proves to be false in some material regard. And the question in those cases is he warranting that this answer is correct, or is he simply saying, this is what I've been told, make your own inquiries? That's a judgment which obviously will depend on the particular question and answer. So a seller can give an answer which is inaccurate but truthful, and that is where he isn't entirely accurate, but the difference between what he says and what is true isn't regarded as material by a court. And materiality, according to the cases, means would it affect his decision whether or not to buy? Would it affect the terms on which he bought? If the answer to those is both no, to both of those is no, then it may be inaccurate, but it is not a misrepresentation. The converse is you're more likely to come across, which is something which is the half-truth. That's something which is literally true, but is misleading because of something which is not said, which is not added. Now, an obvious example is questions, I think, 7 onwards, which say, are there any rights which the property or rights or arrangements which the property has the benefit of? Are there any rights which the neighbours have over this property? If yes, please answer. And if you put one down, say for example there are 3 adverse rights, but you only put 1 down, you are impliedly representing what you said is literally true. That right does bind, but you are impliedly representing that that is the only rights, at least that you're aware of, and therefore by omitting the other 2, you've committed a misrepresentation. It is a half-truth. The other example is the William Sindel example, is the seller aware? And if you haven't made inquiries, you may be truthful in saying, I am not aware, but you are misrepresenting the situation because you have failed to make reasonable inquiries and you have representing that you have done so. Okay. So, audience participation time. Let's test what we think about this. So, I mentioned SPIF 3.1, 3.2. Have any notices or correspondence been received or sent, or any negotiations or discussions taken place which affect the property or a property nearby? 3.2. Is the seller aware of any proposals to develop property or land nearby? So, nearby, affect, and then in one it's notices or correspondence, and in 2 it's proposals. Okay, so we'll have a show of hands. Seller is told by his neighbour that someone else down the road is planning to convert their house into a house in multiple occupancy, and that'll be the first one in the road. Is that a proposal to develop land or land nearby? What do we think? Hands up who thinks it is. And hands up who thinks not. There's no right answer or wrong answer. It's just interesting to see what people think. I'm not sure myself. I think if it's simple tittle-tattle, this is what I've heard, says the neighbour, it may not be a proposal. It's certainly not notice or correspondence, which I think are always going to be written. What about this? The neighbour says he fears that a new supermarket's going to be built nearby. Proposal to develop, is it a proposal? No, I think we can all agree on that. Okay, how about this one? Show of hands. On the local news, there's a feature which says that the local authority is applying for government funding for a new road a new bypass which is going to affect this property. Is that a proposal? But bearing in mind, of course, that funding may come in several years' time, and then they need to apply for planning permission. Who thinks that's a proposal to develop property or land nearby? Few nods, few hands going up, a few people shaking their head. All right, what about this one? There's going to be a waste recycling centre opening up in your locality. It's going to be fairly far away from the property, but nevertheless, it's going to make the neighbourhood a bit less desirable. Any proposals to develop property or land nearby? It probably is, I think. But what does what happens if you got a notice to affect land nearby? What does nearby mean or affect mean? Well, there's some guidance in a first instance decision of Thorpe and Abbott's. This was on an earlier version of the form, so put us all out of our misery. What the court said about effect was this. Affecting the property, in my judgment, requires that the possible future event will, if it happens, have some effect on the property itself or the use or occupation of it. A possible effect on its value would not be enough on its own. Nor would a general effect on the locality or the desirability to purchasers in the area or the property itself be sufficient, as, for example, it might be the case if the seller had received a notice of the closure of a local school or hospital. The effect need not, however, be direct physical interference, a material increase in noise or smell, or an adverse effect on views from a property would, in my view, potentially affect the property. So you can see that these are difficult matters of judgment here, and unfortunately there is no clear answer one can give that covers all these situations. The third main element that the buyer must prove is that he has been induced to buy. In practical terms, this isn't really a problem for most buyers. They have to show they were entitled to rely, and they did rely on what was said. You have to say, there's certainly answers to the SPIF are ones on which a buyer is entitled to rely. Sometimes factual reliance can be a bit of a problem. What you need to show is that it was present in the buyer's mind and influenced their decision to buy. You don't need to show that it had decisive effect. You don't even show that but for the fact that the misrepresentation was made, he wouldn't have bought. But it has to play some role in his decision to buy. I have to say that some buyers, when they come to you and say, I relied on this, and you go, really? Did you? Were you aware of it? They go, yes. And you know that, well, there's perhaps a little bit of ex post facto rationalisation going on as to what was truly in their mind. I think the one significant thing that you come across on this element is really the no reliance, no representation clauses that you often find. Most of them are qualified by saying no real representation except one made in writing, so it doesn't cover the spiffs and so forth. And the approach of the court has differed so far as these two different types of clauses are concerned. In some cases, the court simply said, well, that clause is just an element that I throw into the mix in deciding whether, in fact, the buyer relied. Nothing more than that. Other cases have taken the opposite view and said, well, it's a contractual bar. You are agreeing, effectively a form of a contractual estoppel, that did not take place, even if it did. Other cases have said, well, actually what it does is it defines the extent of your duty. It's not a limitation on liability. It's saying this is what are called basis clause. This is the basis on which we contracted. Therefore, it falls outside legislation against such clauses. The current position seems to be that pretty much whatever the form of the clause is, it's regarded as an exclusion clause, and therefore it's going to be subject to the reasonableness test in either Section 3 of the Misrepresentation Act 1967 or for consumer contracts Section 62 of the Consumer Rights Act 2015. Okay. I said there were, apart from the 7 common elements, there were some extra elements you needed to prove. For fraud, you need to show that the seller knew that what he was saying was false, or was reckless as to whether or not it was false, and he intended the buyer to rely on it. What you needn't do is show that he intended to mislead the buyer. So, for example, there was one case where a seller purposely answered a question wrongly, and the reason it was about any service charge arrears, and the reason he did so was because he thought that wouldn't adversely affect the buyer. Wrong. And he relied on that as saying, well, look, I didn't intend to mislead. I thought it didn't matter whether what I said was right or wrong. The buyer wouldn't be responsible. The answer is, it didn't matter that you didn't intend to mislead. You knew that what you were saying was false. Okay. Negligence, it's duty of care and breach. And duty of care, formulated various different ways. It's either the assumption of responsibility or the special relationship. There's sort of Esso and Marden representing the throughput of a petrol station, Esso misrepresenting that, or the anticipated throughput. Duty of care, but the reality is that in all these sorts of cases, there is a special relationship between the seller and the buyer, and there is because there's special knowledge on the part of the seller that he knows about the property and the truth or otherwise of the questions he's answering, and the buyer isn't able to independently verify the truth or otherwise of that, or at least not to the same extent. It might be different where the seller, as I say, is simply passing on, to use an example I used earlier, the seller is simply passing on information he's got from a third party, and the buyer could himself verify whether or not what the third party said, for example, the local authority, was true or not. Section 2.1, I said, which is effectively statutory negligence, what it says is, and the reason why it says it's negligence is this, it says a seller is liable or is liable to representee without reference to any burden of any duty of care. But then it says there is a defence if the representor believed and had reasonable grounds to believe that what he said was true. That, says the court, is effectively the negligence duty of care. So in other words, if you believed and had reasonable grounds to believe, therefore you wouldn't be liable in negligence either. The difference between the two is, well, we'll come on to one of them, twofold, between negligence and Section 2.1. Section 2.1 flips the burden of proof. So whereas the buyer has to prove duty of care and breach for negligent misrep, under Section 2.1, it's the burden on the seller to prove he believed and had reasonable grounds to believe. The other difference we'll come on is as to the measure of damages between those two. What remedies are available? Rescission, first of all. Well, of course, a buyer is only likely to want that. He's more likely to want that in a falling market, which we're not, of course, currently in. It's the only remedy, as I mentioned, for innocent misrep. It's subject to subject to equitable defences, late cheese, acquiescence, and so forth. But the court, as I mentioned earlier, can grant damages in lieu of rescission under Section 2.2 of the Misrepresentation Act in all cases except fraud. Damages, statutory damages, Section 2.1, and common law damages are for fraud and negligence. Now, for fraud, there's a different measure of damage, and Section 2.1 adopts what's called the fiction of fraud. So it gives you damages assessed on the fraud basis, not on the negligence basis. So given that you've got a reversed burden of proof, given you've got a potentially higher loss claim under Section 2.1 than in negligence, it seems to me you would be foolish to run pure negligence and not Section 2.1 where that was available to you. Okay. Damages. Your main measure, as I say, is a tortious one. Therefore, it's price paid versus actual value. Okay. And that's true for Section 2.1 for fraud and for negligence. Okay. That's your primary measure of loss. Secondary measure is consequential losses. And this is where there's a difference that's apparent. If you're claiming in fraud or under Section 2.1, you can recover for all losses directly caused, whether or not they are of a foreseeable kind. Whereas under common law negligence, you would have to prove that was so. Okay. So that might include, for example, if you had to trading losses of a business that you bought that you wouldn't have bought but for the misrepresentation, or extra repairs that you've had to do to the property, stamp duty, mortgage, and the like. Okay. And I should say also, you may have, in the period between contract to completion, you might, as the buyer, have a defence to inaction for specific performance by the seller. Okay. The third potential claim, the final one, I'll do very quickly, non-disclosure. As rare, in my view, almost as rare as misdescription. And the reason is this. It's a contractual claim, I should say, just as misdescription is. The reason is this. The seller has an implied duty to convey the property free of any undisclosed defects. Okay. And that's the important thing. So it's got to be a defect which is latent, of which the buyer is unaware because it hasn't been disclosed or he hasn't come across it anyway. So in fact, it's not really a duty of disclosure, standalone duty. What it really is the seller having to qualify his contractual duty to convey good title free of any undisclosed encumbrances. So it doesn't really actually, it's not really something that is a freestanding claim. Okay. It's almost always subject to whatever the appropriate standard conditions of sale that are incorporated into the contract, which will limit or qualify when and in what circumstances the buyer can claim and what their remedy is in those circumstances. The other reason why it's very rarely come across in practice is because it's a remedy that's only available, a claim that's only available to the buyer in the period between contract and completion. Once completion occurs, this claim drops away, and if the buyer's got a remedy, it's in the implied covenants for title in the transfer itself. So there's a very limited window of opportunity for a buyer to realise that he has a claim and to assert it. Remedies are identical, I think, to the ones for misdescription of the property, and you'll see them in the notes. Effectively, they are if the defect, well, the difference is substantial, he's got a defence to an action for specific performance and he can rescind. If they're not substantial, the seller can get specific performance, but only subject to an abatement in the price. The buyer can waive and himself, whether it's substantial or not, the buyer can himself waive and go for specific performance plus an abatement himself. Okay. But almost as rare, as I say, as a claim for misdescription. Okay, that's all I wanted to say. So, are there any questions?
On the SPIF, if you've had a notice and then the planning permission's been refused, do you then answer and say, yes, I've received notices, but it was refused?
I think you do. I mean, you can't say, no, I haven't received a notice, simply because of the fact it's non-operative. The reality is that you have received a notice. But
at any time during your occupation?
Well, yeah, that's right. I mean, it isn't, let's just go back to the wording. Notices of correspondence being received or sent, which affect the property or a property nearby. Now, I think some of the formulations of this are during your ownership of the land. The current version, I don't think is qualified in those circumstances, and you may want to answer it by saying, during the period of time I have owned the property, X, Y, and Z, and qualifying it in that way. Yeah. Yes.
What about statements made by agents? So
Yeah.
you've got a team in your sales office who are perhaps saying whatever they might want to say to encourage people to buy properties, and they're just sort of made in that phase of the show people around. I'm just thinking of what the distinction is between what's said in that kind of honeymoon phase where you just see the property and you really like it, and the actual legal bit as to what would amount to a statement that could be relied upon.
Yeah.
When we're acting for developers selling, that seems to be the biggest issue, is things said by the sales office.
Those are like the old sort of claims that you see in the textbooks about, you know, the difference between, they used to be called mere puffs at the time, or I think they're called just sales talk nowadays is the modern formulation. Fertile and improvable, that sort of thing, you know, description of land. The dividing line between the two is quite difficult, I think. And it's a very fact-specific, it's a very case-specific answer. There are occasions where your special knowledge of the land turns what might otherwise be a puff or sales talk into something else. So if you say, you can do this on the land, you might, because you own the land, you might be representing that's the case. Whereas if if you hadn't owned the land for very long, for example, or you'd never used it in that way, saying that you could do that might be found not to be a representation because it was just an expression of your opinion. You couldn't be thought to be expressing special knowledge about it. I mean, can you give me an example of the sort of wording that you sometimes feel a little bit concerned about?
Well, we've got a site where it's next to another site which would be used for very noisy activity, but hadn't been
Right.
a period of time, and representations were made in the sales office that, or representations, comments were made that, oh no, they're not coming back, and
Oh, well, that's potentially problematic, I think, if you say it will not happen again. I mean, you're not warranting, I think, that it will not happen again. You're not making a contractual promise, but you, I think, are showing that you have a reasonable basis. That's the Williams-Sindel case, for thinking that that is so. And if you've made no inquiries and you have no basis for saying that, then I think yes, that's potentially a difficulty. Equally, if you say this is a very quiet area and they've because why? Because they stopped the jackhammers last week. Yeah, that is quite clearly a misrepresentation if you've no reason to think that it won't start up again. There was an example in the cases in the notes where somebody answered the question, are there any disputes? And they answered no. And in fact, there'd been running disputes, but this was just a period of calm. So are there any disputes was held to be, to answer no was held to be a misrepresentation because you had no reason to think that the neighbour wouldn't kick off again in next week, as happened, which is a similar sort of case to your example. So yeah, I think in those circumstances that's potentially problematic, unless, as I say, they have reasonable grounds to believe that the noise won't start up again. And proving that is going to be quite difficult, and documenting it is going to be equally important as well. Any other questions?
On the dispute, sorry.
Yeah, no, that's fine. I'm just. It's lovely to have questions because usually there's a thundering silence, and yeah, sorry.
What would you class as a dispute?
Well, $64,000 question, isn't it? This is where as I say, it's a question of judgment rather than opinion, but maybe a distinction without much of a difference in reality. A dispute, it seems, well, if something has been resolved, if this, if it's, do you mind if I do this? No, that's not a problem. I think it becomes a dispute at the point where, very keen to call us, aren't they, in this room? It becomes a dispute at the point where there is the potential for it to become litigious, in my view. Not that it will, not that it's threatened even, but it has the potential, a realistic potential of becoming litigious at some point in the future. It seems to me that's a fair test of the dividing line between what you must disclose and what you can not do so. Yeah. Hard though. As always, I mean, yes, of course, you don't want to put the buyer off, but certainly from the solicitor's point of view, as I say, what you want to say to your seller client is disclose all of this, and it's up to them if they do, and you can tell them the risks if they don't. You're in the clear as far as the seller is concerned, so if the buyer comes after the seller won't come after you for saying you should have told me differently. You won't be liable to the buyer because there are cases which say that the seller solicitors don't owe the buyer a duty of care to ensure that the answers are accurate. So you're all right, and then leave it to the seller to, you know, as long as they're warned about it, and ultimately it is their form, get them to sign it rather than yourselves as well. It's going to be their call.